Respected ma'am and dear participants, a very good evening to all of you. I, Savraj, member of Legal Vidya, welcome you all to this certificate course on advanced legal drafting. So today's mark your 16th class. So without any further ado, let's begin the class. Over to you, ma'am.
Good evening, Legal Vidya, and good evening, everyone present over here. So, the today's class, we will discuss, and I think just 10 to 15 minutes before I just shared the today's class PDF in the group. I think every participant who are in there in the group or joined the class have received the PDF. So as per the schedule, okay, Srishti. Okay, as per the schedule, today's topics are about. Wait for a second. Today's topics are about the preliminary objections, the submissions, and the paragraph-wise reply on the merits. Three are the topics. Okay, before just today I am not just in the mind like to share the screen because there is no such thing to share upon the screen. If you wish to, then I will, else you just open the PDF in your mobiles only, because that is a today's topic is not about any kind of a draft. Today's topic is more about the law. So just have the pen paper with yourself, and I will explain you everything, and try to pen down whatever the important ingredients or points are there when I will explain the law. Yes, in the yesterday class and the day before yesterday class, as we started with the CPC drafting, we started with the plaint. Then the plaint was followed by the written statement. That is, what are the things being mentioned in the plaint? Either they are admitted by the respondent or not, or what are the other refusal grounds or rejection grounds of that. So regarding that, we have prepared yesterday, drafted the written statement for the same, and for that written statement, only on that behalf of the written statement, today we will discuss what are the objections. As you everyone is okay, just I'm not sharing the screen today because there is no such draft today, and already shared whatever the notes of the topic are there, and it's a very detailed PDF, so you can just go through, and it's not possible to just scroll down the PDF every time. Okay, Bhavna? Yes, okay. Now as you all know that aware of that, yesterday we have discussed about the drafting of the written statement. Written statement means kind of a legal document that is prepared just to admit or to reject or claim new aspects for the suit being instituted by the plaintiff. Now regarding that, in the today's session we will discuss what are the objections. So when any of the deponent or the respondent comes to the court or being summoned just to file the written statement for the same, then unwritten statement is being filed in the court on the behalf of the merits, on the behalf of the certain technical things or the certain technical parts, grounds that is being mentioned in the plaint. But when it comes to the part of the written statement, not every aspect is being accepted, not every favor is being taken by the respondent. So in the civil litigation, it's just like a technical thing on which you can win the case or on which you can lose the case. Now that is a very another thing that you are winning or losing. Our goal is just to discuss about what are the objections that are being taken in the civil litigation. Now the objection are being taken in the civil litigation in the form of a written statement. So there are certain kinds of objections that are being stated. We'll try to maintain all the mention all the uh, objections I have mentioned in that the particular PDF also. If anyone meanwhile have any query, then please they feel free to put in the chat box. Meanwhile, I'm just discussing. So you all must be acquainted with one thing, that plaintiff put a lots more allegations in the plaint, or the plaintiff put lots more things or the points where he just putting the allegations, or he is the victim of the certain circumstances and so on. So regarding that, if there is a person who is just the victim of the circumstances or certain things, a right party is there, they will file a plaint or the civil suit. Regarding that, the respondent will be summoned by the court, and then it's just like they have to file their own think their own technicality. So if the certain things are being mentioned in the plaint, then what are the grounds of the or rejection we can say, or objection we can say, that okay, these are the things not admitting by the plaintiff, deponent, or so on. So first of all is just that the objection as to the jurisdiction. Very important thing is regarding that the jurisdiction is just like a very important aspect regarding the either it's the civil litigation or either it's the criminal litigation. Jurisdiction play a crucial role because jurisdiction means it's a power or the authority of the court to hear or decide the particular matter. If the court is not in the position to drive the jurisdiction from the statute, then what would happen? Then it's just like the trial is just outdated, it's just wasted, and the judgment that is being passed by the incompetent court without any jurisdiction will result in the nullity, and those kind of a judgment shall be vitiated. So the validity of the degree will be challenged in such issues. So judgment, so there is a particularly objection as to the jurisdiction. Now the question comes into the mind that how we will come to know that the particular civil court have the jurisdiction or not. Then section number 9 of the CPC particularly provide the same, that when you go through the section number 9 of the CPC, that is being stretched by adding the word nature along with the civil, which means that the court has to hear the case suit or not. If the civil is there, but the suit is must be of civil in nature. Okay, so now there is a point in the PDF also regarding the civil nature suit or the criminal nature suit. If the particularly what we the as a law student we see that the civil law is particularly concerning, or it's all about resolving the dispute between individuals, between the organizations or wrongdoer, and the on it's just about compensating the victim. So two parties are there particularly. But where we talk about the criminal laws, it's an offense or the crime that is being committed against the society as a whole. So that's why the here that the respondent is the state. Now comes the another aspect, that is the and another objection, that is the objection as to place of suing. Very important part, and here we will just uh, uh, take the scenario of section number 15 and section number 21. Place of suing means the venue of the trial, means that the court in which the case is to be tried. So for that there is a general rules also. Suit must be instituted in the lowest grade court competent to try the suits, and this is what the section number 15 says. So now the section number 21 states that the defendant has to take the opposition to the place of the suing at the earliest opportunity. If the opposition can't be taken in the appellate court or the revisional court unless it was taken at the court for the first instance, that it was rejected. So first of all we have to follow the section number 15, then we have to follow the section number 21. Place of suing also depends upon certain things, that is the pecuniary territorial jurisdiction to the subject matter, and jurisdiction pecuniary jurisdiction. Now if there is anything like a territorial jurisdiction, means that within the court must be within the local limits particularly, and the section number 15 say so. And local limits means that for example local area is just like where the wrong thing has been done, defendant reside or defendant carries the business or defendant works for gain. Or in case of a pecuniary jurisdiction, it's just like a pecuniary jurisdiction means like every court has the pecuniary limit. They can't entertain courts any kind of a suits of the cases beyond that limit, and that is just like a valuation of subject matter to the suit. So the valuation must be just like if the for example, we will take the example of Rajasthan or the UP particularly, where senior civil judge is less than and equal to 5 lakh, civil judge less than or equal to the 2 lakh. So this is the jurisdiction, and that are pecuniary jurisdiction are particularly decided by the High Court of the concerned state. Now the party can also take the objection that the suit is not filed in the court of lowest grade. These are the certain objections that the parties can take. Valuation exceeds the pecuniary jurisdiction, court doesn't have the territorial jurisdiction, the matter of the suit is not situated within the jurisdiction of the court. There is another doctrine also, that is the section number 11 says so, doctrine of the res judicata. Doctrine of the res judicata is also applicable. It means that the rule of conclusiveness of the judgment is based on the need of giving a finality to the judicial decision. The rule of the judicata also states that once a matter has been finally decided, by the competent court, then no party can be permitted to reopen it or in a subsequent suit. So this is what the res judicata says so. And now there are certain res sub judice also, that is the doctrine under section number 7, means that the stay on the suit is a restriction on the court and try not to try a suit which is directly substantially an issue in the suit. So these are two things that is can be made to the objections, that is the objective to the doctrine is to restrict the parties to a single suit and to avoid any possibilities. Now there are certain other objections also. Objection is just like for example, objection as to no cause arises. For example, no cause arises means that plaintiff approaches the court. Very simply we can take, the plaintiff approaches the court. The basic presumption is that the court take it that there is a cause of action because the plaintiff has come to the court. But now what happened? The cause of action is what? It's a kind of a bundle of essential facts which is necessary for the plaintiff to prove the court and to give the plaintiff the right to seek any relief against the defendant. But what would happen if there are no as such thing that the happened, or there is no as such authenticity in the facts? Then what would happen? So no cause of action arises. So that is also the objection taken up by the court. Now the objection as to the limitation period. Section limitation period is calculated by the section number 3 of the Limitation Act. Now the section number 3 of the Limitation Act, I think 1963, that provides particularly that the every suit instituted, appeal referred, or the application that are must be made after the prescribed period shall be dismissed. Means that the for example, you must be acquainted with one thing, okay, you have to file the appeal in the 15 days, 20 days, or 45 days. How many of you are acquainted with this fact? Let me know. Either the session will be monologue. How many of you know that there is a time period for filing the application, bail application? It's a 30 days or 45 days. 15 days is their revision. You have to file in the 15 days. Have you heard these things during the litigation or the when you were studying law? I think everyone have studied those things. So these are certain aspects of the suit. Yes, Shrishti Bhavna. Yes, I got you. Only 4 to 5 students are there regular in the class. Yes, those are also the things that the objection is just like the beyond the limitation period, the suit is being instituted, appeal is being preferred, or application has been filed. So these are the certain instances. Next is the objection as to the non-gender for the misjoinder. It particularly like there are for example, we already know that plaintiff and the defendant are the necessary parties, then they are directly related to the suit. However, if any of the third party who has the interest in the suit is not directly involved but involved proper property and not a necessary party, then what would happen? The plaintiff have to include necessary party and proper parties of the plaint. Apart, wait for a second. Yes, a necessary party means a person who is just essential for the constitution of the court, and without his appearance, the case can't be decreed, or the case can't be sought, or the relief can't be granted at all. So, where means the party that is interested party whose appearance is dispensable in the court's presence. In the absence of the proper party, the court can issue effective orders, but at the time of passing of the final decree, the appearance of both parties is necessary and essential. So the parties can also raise the object on the following grounds: that the right to opposite party has not been violated by objecting party, but the some other person whose appearance is necessary to decide the suit has not been made a party to the suit. The next thing is that the right of the opposite party has been violated by the objection, but such violation is not forming part of the same transaction. So these are the certain things. Then next is the misjoinder of the cause of action. The same thing is the end of the cause of action. Those subject matters are given under rule number 2, order number 2, rule number 3 part 1. If there are in any suit, cause of action can be joined together in a single suit or separate suit can be filed on each of the cause of action. The necessary conditions for the gender of the cause is the cause of action is arising in the same or act or the transaction. The common question of the fact of the law is also being involved. So these are also the certain factors. Now the objections on the pleadings. Objections on the pleading is a very important aspect. It's just like that the pleadings are the contentions which the plaintiff and the defendant are every time plead to prove their case. The plaintiff states in his plaint the facts of the case, the cause of action, the relief being sorted, and any other detail that is the plaintiff thing is in his favor. Similarly, the defendant also include the written statement all the relevant facts which make his defense strong and the weakens the pleadings of the plaintiff. So the overall object of the pleading is to narrow down parties into the definite issues and to make the other parties aware of the contention and to prevent the surprise. And this is the fundamental rule of the pleading also, that the parties can only succeed on the basis of what they have pleaded and what they have asked and what they have proved. And on that behalf only the relief can be claimed, or the on behalf of the relief can be asked. Now, another objection can be on the behalf of the objections on the services of the summon. So there are three situations we can consider: summons not served, summons not duly served, summons not served on the time. So these are certain circumstances that the objection on the services of the summon can be considered. After the suit or instituted file, application being filed, appeal being filed, the court issue a document to inform the defendant that okay, this thing happened, the suit being instituted, and instruct him her to come and prove his case in the court. The documents are called summons. Now the reason behind issuing a summon is that the defendant should be given an opportunity to heard. Let the other side heard. Okay, write in the chat box, let the other side heard. What is the legal maxim, Latin maxim for the same? Let the other side be heard. What's the Latin maxim for the same? Just put in the chat box. I will check it out. Will mm, Audi ultram partum? Yes, Bhavna. Anyone else? Is Audi ultram partum is the correct legal maxim for the same? Yes, Prachi. Yes, this is the correct. Okay. And one more thing is the amicus curiae. Yes, Yuvraj, absolutely fine. Audi ultram partum. I think every law student is acquainted with the same. Next is the amicus curiae. So tell me the meaning of amicus curiae also. These are the legal maxim terms. Now you must know the meaning of the same. Amicus curiae, friend of the court. So okay, who is the amicus curiae here? In the case of a civil proceedings, who is the amicus curiae? Either the plaintiff is the amicus curiae, either the respondent is the amicus curiae. Yes, yes. Anyone, please mention in the chat box. We'll take it afterwards. Yes, Praveen, you were saying something. Friend of court. I understand. Amicus curiae is the friend of the court. Achha. Okay, be active. I will just ask another things also. Let's just complete this first. Okay. If meanwhile having any query regarding the same, just put in the chat box. Now there are the certain objections on the services of the summons also. Because I have make you acquainted with the three circumstances. Now the first circumstance is that the summons not being served. When the summons are not being served, then what would happen? Then it's just because of the failure of the plaintiff, and the failure of the plaintiff is just like he doesn't pay the court fees or the postal charges, doesn't present the copies of the plaint, and the copies of the plaint we can read under the order number 9, rule number 7 for the same, or apply, or either he can apply for the fresh summon. Now another thing is that the summons not duly served. This is also the basic reason. Summons not being served on time, summons being improper summons are served. Now another objection is that the objection in the on the basis of the discovery means what? Compelling the opposite party to produce the documents on which they are railing to prove their cases. So it's important that the defendant to have the access of those documents, and just to prepare the defense against the contentions of the plaintiff, particularly that okay, what are the contentions they have made in their suit. So we have the document to prove that okay, their points, whatever they have mentioned, is just wrong. And the discovery can be made by two methods. Particularly, this is what you have studied in the civil CPC also. By the interrogatories, discovery by the interrogatories, or discovery by the inspection of the documents. And the discovery by the inspection given under the order number 11, rule number 3. So you can refer the rule number 3, order number 11 also. Interrogatories discovery is there. Now comes a very important aspect, that is the objection on the behalf of the valuation of the suit. If the plaintiff has calculated the value of the suit subject matter for the purpose of the pecuniary jurisdiction of the court and to ascertain the court fees, sometimes what happened, the lawyers undervalue the matter in the particular case and the save the court fees. In this case, the defendant can voice the objection against it and can request the court to reject the plaint under order number 7, rule number 11. Now there is an objection on the behalf of a defective prayer, also objections on the behalf of the plaint not duly stamped. So these are certain objections that are being made on the behalf of the defendant. Other technical objections may also include non-compliance with the statutory provisions mentioned under the Limitation Act or the Civil Procedure Code, CPC, or the petition is signed by the person not authorized by the plaintiff and the defendant is not cured within the time granted by the court. Here the time, what the time granted by the court is not the limitation time. It's another time. It's a court giving you the warning. You okay? Come and amend your pleadings. Yes, Bhavna. Please give example of the objection on the valuation of the suit. Okay, objection on the valuation of the suit is just you can like for example your first of all the object valuation part is given under the court can just be like reject the plaint on the behalf of the under valuation of the suit under the order number 7, rule number 11. So just write down this thing first, the technical part, that is the order number 7, rule number 11. Now, what happened in certain cases, it's either on the behalf of an advocate or either it's by mistake it happened that the suit is being undervalued and the court fees is not particularly paid. Then what would happen? The defendant, it comes just the on the defendant part to file the WS, then they can just file the objection ki okay, the suit that is being instituted by the plaintiff is undervalued or the court fee is not properly paid, so the plaint must be rejected. It's just like that. And for example, you are asking about, it's just it's a human error, can be, we can say, or sometimes it's just like a advocate knowingly doing so because he is just not loyal to his client, so on. So these are the aspects, Bhavna, where the plaint can be rejected. These are the certain aspects. Yes, anyone else have any question, then please ask. And how many have you prepared the WS and the plaint for the given problem? I just received 2 to 3 plaints till now and WS till now. Just practice on the daily basis actually, then only you can be acquainted with the same. And for a summary brief, I will just recite once again what are the objections. Okay, but these objections are just like no, or these are not the absolute objections. You have to keep in mind one thing: these are not the absolute objections, but the respondent can take a kind of a slight, we can say, a weightage of the fact, or he is just like is he lucky enough to take those defenses, and those defenses work in his favor, due time favor. So it's just like a 50-50 kind of a thing, or just like a by luck. Yeah, the law is also there for the in the name of the same. I am not denying to the fact that law is not there, but either the law is there, but there is a scope of the rectification every time. Now, how many of you are just agreeing with this thing that okay, the plaint is being undervalued, okay, the verification is not complete, the plaint is not completed, and then the court is just like giving the warning to the plaintiff just to complete the plaint and just resubmitted or the refiled it again in the within the given time period, and the plaintiff did so. Then what would happen? Does the deponent will be there to able to take the stand for just rejection of the plaint? You tell me, how many of you are agreeing? Did you understand what I'm trying to say or what I'm trying to ask? Oh, no one will be there. Should I repeat the question? No, ma'am, you didn't get it. Okay. I'm just repeating. Okay. Yes, Anamika. Yes, Sony. I have mentioned here certain grounds for the objection. Did you get these grounds? I have listed certain grounds that on which behalf the respondent can take the defense, and they can be just like, okay, ask the court to reject the plea. You got it? Okay. But now what happened if in any of the circumstance, for example, we will take the Bhavna's example, as per she is saying that the objection on the valuation of the suit. Okay, any suit is being instituted in the court and that is undervalued. Court fees not properly paid. And then what would happen in that case? The respondent will take the defense of the same, that the court fees is not properly paid and the valuation is undervalued, so the plaint must be rejected. How many of you are agreeing to the thing? Let's take it word by word. Okay, yes, yes, got it. Okay, now what happened? The court take the cognizance of the fact, and the court has given the another chance just to refile the complaint in the court, and the plaintiff just refile. Then what would happen? Is there any defense mechanism left over for the respondent or not? Yes, and again the plaintiff should be given another chance to file again, because might be a human error. Absolutely agree. That's what I am saying. It's a human error. Yes, Nagendra, absolutely right. Now, how many of you are agreeing that that is not a more than that is no more a defense mechanism for the respondent if there is are certain rectifications made by the plaintiff after the court has given the warning to the plaintiff to make the to correct the changes? Now you tell me. Did you agree that there is no such relevancy of the objections there? Once the court has asked that, okay, just ask the plaintiff to make the changes to do the ratifications, then the plaint is being just like, okay, prepared and prepared, and then being suit being instituted or the plaint being filed. Then what would happen? All the objections must will be deleted, will be removed. Then would what happen? The respondent will be able to take the objection or not, defense or not? It's not, actually it's not. I think you people didn't get what I'm trying to say. No worries. Still, we will continue with the class. Yes, anyone please have any query regarding the same, please put in the chat box, because there are certain objections that I have discussed already. Next, we will move to the another part. No one have any doubt or the queries or in any of the previous sessions query? It's not about as I'm asking about what I taught today. So you start asking me, you didn't prepare yet, you didn't study that. I think you people are done with the criminal drafting. How many of you have practiced the criminal drafting? And how many have you done with the same? How many have you practiced the bail application? Okay, Bhavna. Yes, Akash. Okay, Shishti. And how many have you done with the anticipatory bail? Okay, okay. Shishti. Okay, Shishti, it's just enough to give a one, just once a thumbs up. Yes, Rahul. Okay, no worries. Okay, so these are the objections. Objections, we can say, I am just briefly explaining once again. Objection is to the place of suing regarding, objection for the jurisdiction, objection for the subject matter, objection for the, we can say, limitation period, objection for the cause of action, objection on the pleadings, also objections on the servicing of the summons. Objections, they are just like summons not being served properly. Objections are just like on the behalf of a discovery. So there are certain objections that can be filed, and the defense can take the mechanism for the same. So these are the objections. Now what happened? The another topic is just reply, paragraph wise reply on the merit under the CPC. So paragraph wise replying is nothing as such mentioned under the CPC, but if it's a topic given in the class, we will discuss it. Okay, now what happened? We are discussing with the WS, written statement. Okay, now in the earlier classes session, we have discussed about the one thing, that is the legal notice. How many of you are aware with that we have discussed the legal notice? Okay, okay, yes. So we will jump to that legal notice only. Now, what happened when it comes to the reply to the legal document? Then what happened? It's just like a plaint being instituted or a plaint being filed in the court. Now, the defendant being summoned, that's to appear in the court, and they are given with the plaint copy, and they are just asked to submit the WS till the next hearing being stated. Okay, now what would happen in that? It's just a matter, not a matter of a concern, but it's just a matter to be deal with the most calm thing, because whenever there is a practicing law, then it's just like you have to prepare or draft the that WS written statements on the regular basis. So drafting by of the WS, we can say, is just like not following particularly a very different format or different pattern other than the plain in which other than the general WS format, but it requires certain additions. So additions means what? If the any of the layman that is being rushing that okay, the suit is being instituted and he is issued the he received the summon for the same, then what would the duty of the advocate here? Advocate will be just like format and language of the that legal notice, we can say, or the plaint will be like doesn't change much that of a WS, but it just includes the general format, and it will also incorporate some of the additional details and the paragraphs of the actual cause of action. So first of all, we will start it with the body to the reply. And there is no such law behind the same. Yes, one thing I have to clear, what I am telling you is just it's just a topic of understanding. Nothing has to share upon the slide or to write upon the slide. That's why I didn't share the screen today. And the PDF I have already shared you with the objections list, which you received in the group. Now comes that what are the particular merit wise answers or the things reply, that is particularly deals. First of all is the body means that it's a mixing of the process of replying to the any plain questions, or it's just making any kind of a notice. Then the reply starts with the mentioning of the details of the summons received, for example, on the behalf of whom, from which court, what are the details, what are the dates. And if it may contain mentioning of the claims of legal things received as false or something as clear nature, then what would happen? It will start with the preliminary objections, and then it is just move to the replying on the merits. And when it comes to the replying on the merits, then the point wise maybe things maybe just containing certain headings can be drafted. Now where the process is very much similar as we drafted the rejoinder application or as we draft the general WS. Now what would happen? Another is the concluding reply that we have to give when the entire body of the WSB is prepared and incorporating certain clients version of the event or the respondents version of the event, then the format of the legal we can say merits or the WS is where the law relied upon the remedy that is being included. Now the general few last paragraphs will be just like when the sender or the source from where we receive the summon is just to reply of that legal summon that is laying down the instructions for the entity who receives the legal kind of a summon for some on the behalf of such a plaint, and so on, along with the warning and the consequences. The particular main thing that is that both here the respondent and the plaintiff are very well aware about the cause of action. So to ensure that the reply must be just like with the inclusion of the defense mechanism, it's the duty of the advocate only to ensure proper conveyance of the necessary communications, and it's the duty of the advocate also, just not being an engaging lawyer, there must be agreement between the lawyer and the client just to represent the client. So when it comes to the replying on the behalf of the merit, it's just like a none other than it's like an important part of the proceeding, and they would only allow the plaintiff to just take forward, or the court they will just like make the easy thing for the court just to for the opportunity to just consider the claim before the court of law that has been railing their versions of the event and staying by it and from the death go. So and preparing a WS on the behalf of a on the behalf of a marriage is just like also lead to the reaching of a resolution. So with the intention of the entire process, when we draft a legal when we draft either a legal notice or the written statement, few changes must be there with the certain objections being included, certain we can say grounds for the rejection of the plaint, or if there are something cause of action has been there, or there are something that the evidences are against us, then those points are also being mentioned. But you can be just like rejection, you can ask the court to reject the pledge on the particular certain grounds that are actually existing. So these are the things that we have to consider. And today's topic is more about the drafting of the WS. And draft of the WS I have shared you already yesterday. Yes, anyone now? That's all for the today's session. Anyone now? Please have any query? Ask one by one. Just would like to solve all your queries. What are the objections against the witness evidences? Sodi, how could you file the objections against the witness evidences? No such objections are being filed against the witness evidences. These are, that is the cross examination. When the witness is being called in the court, then the cross examination is done. Bhavna, who is amicus curiae in the court? Plaintiff or the defendant? None is the amicus curiae in the court. None the plaintiff or none the defendant. Plaintiff and the defendant both are the parties of the suit. Bhavna. Yes, Anamika. It's none. Both are the parties of the suit that is being instituted. And for the objection against the witnesses of the evidences, it is, and witnesses are being evidences are given on the oath. And most important thing, the cross examination is there. For example, you do the rebuttals in the moot court, na? Same as that. Naginder, yesterday's session, please, you can just watch on the YouTube. It's all about the WS. If you miss yesterday's session, please, they will share, Legal Vidya will share you the link of the yesterday's session that is all about the WS. I have discussed in detail about the draft of the written statement. Written statement is a legal document particularly that deals with the what are the allegations being put forward in the plaint that are being filed on the behalf of the respondent and the deponent. You can just refer to the yesterday's class. Yes, anyone else have any query? Please feel free to ask, because I'm here not just to tell you about the drafts and any other law also. If you have the query, as seen in the movies, one advocate forces a legal witness to speak something, the other advocate raises objection, the witness is being leaded. There is no such thing in the real life, Sony. Movies all are scripted. They are for the entertainment purpose. They are not bound by the any kind of a procedure code, either civil or the criminal. There are no as such thing that what we are saying, that the advocate is compelling someone to say something and other is raising the objection and so on. So there is no as such thing. Yes, anyone? Yes, Anamika. It's a malified means bad faith or the bad intention, or intention to deceive and all. In the yesterday's session, if you missed the Bhavna class, yesterday's session, misjoinder and non-joinder, I have discussed in detail. So please refer, because it's not possible for me to just explain the misjoinder and non-joinder in detail right now. Please refer yesterday's class number 14 or 15, I think. Please, I have discussed everything in detail there, along with the notes, or either refer to the notes or the PDFs that I am sharing. Yes, sir. Anyone else have any question? You can ask me anything other than the civil drafting, also any law. You are studying cyber law, you are studying the environmental law, okay. So yes, and there is a one thing that you people participate in the moot courts. If yes, then please participate, because now the JESUP applications are open. If you are pursuing BA, LLB or LLB, then please apply for the JESUP and so on. JESUPs are open. And participate in the your colleges, intra colleges moot court competition. Anamika Sharma, yes, how to you can prepare for the CLAT PG? Yes, sure. I will arrange a session upon the same. How to prepare for the CLAT PG particularly. How to cover the difficult topics like jurisprudence. But jurisprudence is not difficult at all. It's lengthy. And I think jurisprudence is moreover, it's just not like you have to prepare through the book. That is the Pranjape and the Anirudh Prasad book is there for the jurisprudence. For the foremost thing, for the CLAT PG, just make your mind for the one thing. First of all, you have to go through the previous year paper. No matter what, please just go through the previous year paper. Make the notes subject wise, not topic wise. It will be hectic for you also. Or either purchase any book that is providing the subject wise previous year questions, and then as per those things, start preparing. Okay, now for the paragraph based questions, start referring to the leading judgment. I think today only the live law has shared the video of 100 top 100 judgments of the 2024 and 2023. I think today or yesterday they have shared on their YouTube channel. I was just got the notification. So please refer to that. There are certain YouTube channels providing the bunch of the cases, and the leading cases play a very crucial role. And one more thing, that is one magazine is published from the Allahabad, that is the Judgment and Law Today magazine. So please refer that magazine also. That magazine is just like a very important thing. Every law student must be just like handy to every law student. Judgment and Law Today magazine is there. So refer to that, because in that the pieces of the judgment pieces are directly extracted for the paragraph based questions or the case study based questions. And Anamika, just ping me on the WhatsApp. I will share the. I will, if I arrange any session for the same, I will ping you for the same. And if there are any other doubts or the queries in any other law subjects, then you can ask there. Anytime, Anamika. Yes, anyone? Yes, please. You can ask me anything. How many of you are just attempting the AIB this time? AIB forms are also there, na? Oh, Noor and Vijay. Okay, Anamika. Yes, go with the AIB also. That is also very important. Yes, Prachi, obviously. All the very best to the who are just the budding lawyers, just approaching to the AIB. All the very best. Purchase the barracks with the without notes one, and then just. And how many of you are doing the research, particularly doing the writing the research paper and so on? Because being a law fraternity, or being a law student, or being a litigant, you must be just like if you are in the litigation, just your research game must be on point. You must be acquainted with how to use the SCC online, how to use the Manupatra, how to use the HIN online. You must be. You must have the habit of the research, because that will only sharpen your skills, because law is all about how you express, how you put your facts. There is no as such competition in the law. It's just about how you express, how you just put the facts, how you convince the court to give the judgment in your favor. Yes, anyone else have any question? You can ask me anything related to law. Either it's about the constitution, it's about the family law, it's about the contract, it's about the property law, company law, so on. Anything related to law, you can ask me. Because drafting is not a big deal to crack. Just I'm discussing for 1 hour drafting only. And Anamika, I can't find books for Haryana and land laws. Are there? There are just barracks available. Sony, do one thing. Just refer the previous year questions and just start making your own notes for the same. And for that, if there is any guide available for the Haryana land laws, I think single guide will be there. Just just go with that. If I found any of the guide related to Haryana, we'll let you know tomorrow. Prachi, ma'am, can you teach us how to do effective research? Yes, absolutely. Prachi connected with me with on the LinkedIn, or I will arrange the session after the course is over. I will arrange the session for the CLAT PG and the research both. Akash, web pages where the law students e-textbooks can be available. Sorry, Akash, e-textbooks I didn't rally upon, because some of the theory or the content is missing. There were certain Telegram channels were there, but it's not good. Just you can go for the e-barracks, but e-textbook you can't. Uh, uh, b- yes, Akash, go for the e-barracks. Either refer just one or two textbook of the any of the author for any of the subject. Prachi, I will make a session upon the research. Yes, research game must be on point. In declaw journal is just calling for the papers. Refer to the SCC online blogs. That is, there are so many NLUs that are calling for the papers, call for the papers or the seminar to do participate in that also. Because participation in the seminars or doing the research is also just like a plus point for the litigation and for the academic things both. Yes, anyone else have any query? Please suggest book for the legal research. For the legal research, first of all, Mainini is there. Madhukar, Mainini is there. And rather than Mainini, it's a LexisNexis book also. I'm just forgetting the name of the author, but it's a LexisNexis book, and the Mainini is there. Mainini's latest version for the legal research methodology is a very good book. You can refer to the Mainini book without having any second thought. Because everything is same, either it's empirical research or it's a non-empirical research. You have to mention that thing only. And research is can't be, you can't learn from the book, Madhukar, or anyone who is looking for the research. You can't start reading the research papers, whatever the journal you are referring to, either whatever the topic, start reading 10 to 20 research paper before writing. Then only a clear picture will be in your mind to start writing. Yes, anyone else have any query, please ask. What is convenience in drafting, pleading, and convenience practical? Okay, so only very practical question you have asked. Convenience is just the deeds. Deeds. Deeds, like for example, your sale deed is there, your instruments are there, your sale deed is there, your mortgage deed is there, or something like will is there, trust deed is there. So that those are the deeds that we study in the Transfer of Property Act, that are being involved, that are being included in the conveyance. What are the key points that we should consider while drafting a memorial? Okay, Yuvraj, very good question. I think I have done a one session upon the same. If possible, I will share the video. While drafting the memorial, first of all, Yuvraj, tell me that what is the portion of the memorial you are drafting? Because a memorial contain 10 to 12 portions, and every portion have the different demand. If you are drafting the jurisdiction, it's a different demand. If you are drafting the abbreviations, different demand. If you are drafting the arguments, different demands. Arguments advance, different demand. Which issue you are doing it, what is the issue related to, that holds a very different demand. Okay, it's just like a jurisdiction in the criminal case. In jurisdiction, you can be just calculated it be like, okay, does the which of the court under the BNSS hold the jurisdiction to just hear the trial. So that can be just, you can refer to the different schedules mentioned in the BNSS, or either it's better to share me the problem, then I will let you know the clearly. Jurisdiction. Yes, sure, Yuvraj. Moot court is a very good thing. If you are in a law college, do as much as possible moot courts. Start practicing, please. As a speaker, you have to. As a researcher, you have to. Please churn a lot, study a lot, practice a lot, research a lot. Research a lot. A lot means you have to, no matter what, you have to spend his time doing scrolling research things only. Follow certain platforms available. Just go through the LinkedIn, LinkedIn every day, or just go through the research as much as possible. Just follow the WhatsApp channels of the that Baran mentioned. Live law, very important, must for each and every law fraternity belonging to a person belonging to the law fraternity. Much important. Law is about all about is remaining updated. As you know that, okay, today's update I am just sharing you. In the international arbitration, now ICC have changed the name from its ADR is all about the alternate dispute resolution. How many of you are acquainted with ADRs? Is abbreviated as alternate dispute resolution. But today, how many of you have just gone through the today's update? And the today's update is of I think it's 2 o'clock in the afternoon. The update was posted that as per the ICC rules, means International Commercial Arbitration and so on, they just changed the name. Now it's the amicable dispute resolution. Amicable dispute resolution. I will share the link of the same in the group today, Legal Vidya. So stay updated with what is happening around the globe. Stay updated. So that is very important. Okay, amicable dispute resolution. Stay updated with the regionals of other states moot court, international moot courts, and the grand slams also. Just have a very perfect LinkedIn. Okay, I think no one have any query for the same. If no one have any query, please give us a thumbs up. We will wrap the session. Oh, okay. Thank you. And thank you so much, everyone, to make the session interactive. Yes, and if you have any query, then please just a WhatsApp away. You can ping me on the WhatsApp. I will try to reply as I get free. And the weather is changing. Take care. Happy learning. Yes, Akash.
Uh,
Yes,
Thank you,
legal.
ma'am.
Thank you,
Thank
legal.
you, ma'am. Ma'am, if you allow, we can arrange a session for how to do legal research and
Absolutely,
get
I would
PG
like to.
after this
Yes, please.
course.
Yeah, please. Yeah, please. I would like to. I would like to for one CLAT PG and for legal research. Absolutely, must
Sure, ma'am.
much.
We will definitely organize this. We definitely organize
Yeah,
this for
sure.
participants.
Yeah, sure. Yeah,
Thank you
sure.
so much, ma'am. Thank you so
Okay.
much, participant, for joining. Good night,
Thank
everyone.
you. Good night, everyone. Stay safe, stay healthy. Weather is changing, so please take care of your health.